Yeah, that's right. Yeah,
a big turnout.
yeah, that's right.
Oh, we did it 6 months ago.
All right. Well, good morning, everybody. We're expectantly awaiting the arrival of Tony Spagnuolo from Spagnuolo Law, and likely Dick Chan, I think, as well, may be coming with him. But regardless, some legal advice. I'm not sure if they got the times wrong, but I'm hoping they'll be traipsing through the door relatively soon, or this could be kind of an embarrassing. Daniela Williamson, look at the tan. We're also we're on YouTube this morning, so I'm going to click over here and turn off that hiding. A couple things to talk about. The kickoff. So we've got our kickoff on. That's embarrassing. It's really hard to do the screen and this at the same time. Forgive us, all those of you on the Sunshine Coast, but welcome. Our kickoff is on January 25th. So previous Sussex guys and not North Shore or City Center guys, we would used to have it at Capilano Golf and Country Club. We'd have a nice breakfast and we'd have a little pep talk and get our year off and running in the right way. This year we're a little tight on space because we have so many of us. We don't fit at Capilano anymore. So we're doing it at Centennial Theater on the 25th. We're going to have a really interesting panel discussion with 6 or 7 consumers that have worked with people not Sussex realtors, but have worked in buying or selling homes over the past year so that they can share in their stories with us as how things went. So I'm really excited about that. It was they had one at the Banff Western Conference, and it was one of the most insightful things I've ever been to, where people just tell you why they choose their realtors, what they thought of the experience, what they expected from people. So that should be a great discussion. We also have Tracy Richardson, who's a professional stylist for CTV. She's worked with people like Celine Dion, Johnny Depp. She's coming to give us a presentation on style and how you're presenting yourself to the world. So that should be fun. And then I'm going to make a little presentation as well. And then we'll get the year started right with a little kickoff. Cheers to the 2016. The training, the new realtor training that we've been doing on Wednesdays, which isn't just new realtor training, it's just ongoing training every Wednesday. We've got a series of about 10 sessions. We'll restart again come February. So once we get going in February. Hi, Chris.
Good morning.
How are you doing? Great. Good. Good. One of the things we've been talking about with people a fair bit lately is assignment. It's one of the things that we're going to talk to Tony about, I hope. And Kim had mentioned that leases as well this morning. How many of you have been working on leases or have done leases this past year? Like Indian band lease sales? Yeah. And is anyone doing leasing, like commercial leasing, any of that kind of stuff? Not particularly. So the band land stuff comes up, and there's specific contracts. We've got. Have you seen the contract that's specific to? Yeah, it's important. And the leasehold, but not just. So there's a leasehold contract on web forms if you're buying or selling band land properties. But there are some intricacies when it comes to Ravenwood. Yeah, right. So if you need a specific contract for in that development, come see. I know Joe's got a good one available as well. How is it?
Also municipal leases.
Sorry, municipal leases?
Yes, like Taylorway.
Right. Yeah. Do those come up very often?
Yeah.
Yeah. So good to know that stuff. Yeah. That's good. What else should we talk about, Chris? We're waiting for the game. How about the market? I have to do interviews with the media for the next couple of days. It's actually a good opportunity for feedback on the quarterly housing statistics report. The stuff that Royal LePage sent out from Brookfield, which is based on stats, showed an increase in the price of a 2-level home in North Vancouver of like 7% year over year. And I said, "This just not true." So they're revamping those numbers. So that's in 2 months. Yeah, I think so. That's about it. So the message that we're putting out, or I'm putting out, and I'm assuming yours is the same, is that it's just a supply and demand equation. There's nothing available. Right, the supply that's there is junk. Remember when they had the big crisis down in the U.S. and they talked about all the houses that were on the market? But most of the houses that were on the market were not houses people were interested in buying. So they had tons of supply on paper in terms of the number of listings available, but the amount of good product was very limited. So bungalow prices certainly have gone up and outpaced 2 levels in terms of the increase in value. I think strictly because those are typically tear downs, and so people see more value in them. Are people seeing 2-story nice homes but not spectacular homes lagging a little bit?
No.
Like 4 days to sell? Yeah, it's crazy, isn't it? Yeah. Has anyone sold anything over the holidays that surprised them?
Yes.
Yeah? What'd you sell, Rena?
A junkie took an apartment in Coquitlam that gets multiple offers. I thought I'd have it for a year.
Really?
Yes.
And is there product available in the building?
Yes.
But it still flew off the shelf. Yeah, it's
That's pricing too. Yeah.
It's pricing, yeah. Yeah, and I think that's the, as there's talk about the condo market. I know we're overbuilt, but like when you look at the inventory for condominiums and apartments as well, it's way down because I think people are getting pressed out of the home. Someone told me on the weekend that they had their parents were offered for a house they bought in 1987, I think, in West Vancouver. They paid $385,000 for it. Someone knocked on their door and offered them 6.2, 6.2, and they said, "Where are we going to go?"
Oh, I could think of lots of places.
I could have gone a lot of places. I could have gone, but they didn't need the money. They called their son up and said, "What should we do?" And he said, "Well, where would you go?" And he said, "Well, we were thinking maybe we could buy a place on the water." He said, "Well, not for 6.2 anymore. I mean, it doesn't work." And so they love their house, they like their neighborhood, and there's nothing else for them to buy. And so they turned down an offer for I don't know how many fold that is, what a turn that is on their investment. But yeah, Mark.
I have a client who's a lawyer that had the same thing on his doorstep and challenged the agent to bring me the offer, and it was just a ruse to try.
Is that right? That's interesting. So you heard Mark said it was just a way for them to try it. There was no real offer behind that. Yeah. And there is that seems to be the standard when people are out there door knocking now. It's not would you consider listing your house for sale? It's would you entertain an offer? And then people are treating that like it's the ability to go out and start advertising the home for sale. These guys would look at an offer. David.
Yellow light from errors and omissions. Last year, one of the cases that was settled but never went to court, so the results obviously are not public. But it was a case of a realtor not advising properly on price. And our real estate practice manual refers to 3 methods of property appraisal, if you wish. We've got comparable, we've got cost approach, we've got income. We don't have BC tax assessment value,
right?
And that's where the problem came from.
Really?
Yeah, and it cost.
The realtor used that as an indicator of value. Wow.
That piece of paper is the most dangerous piece of paper that I see being used in the world of real estate. Buyers agents will come in armed with that in order to somehow rationalize their offer, and sellers agents who really have never just go and take a course on trying to develop a fair comparable market evaluation is all.
Yeah.
But they're using it.
Yeah,
especially
and it's deadly.
Those that are under licensed, and that's 50% of the industry is licensed since 2008.
Right,
and that's where the bigger use of it comes from.
Yeah,
recent licensees.
Do you guys all get that in the back? The use of that tax assessment data as a fair or reasonable estimate of market value is just treacherous, right? It's deadly. So you have to be very careful on that. Sorry, yeah, Joe. Oh,
Big chance here.
Oh, Dick, come on up, Dick.
Tony's on his way.
Oh, good.
We might do this in the reverse. We might start with questions.
Sure.
And when Tony gets here.
Yeah, that's right. There's a pattern.
I think it's caught in trap.
You got anything to add here? Come on in.
Yeah, I was just going to mention, we continue to see tenancies not be properly handled. If you have a listing and there's a tenant in the property, you want to take a good look at the tenancy agreement. You want to make sure it's an official tenancy agreement from the residential tenancy office, because those RTO takes trumps any handwritten tenancy items that you might see. And so even if it has terms on booting the tenant out quickly or whatever, you still have to live by the terms of the residential tenancy office. So if you do list a property with a tenant in it, make sure you get a copy of the tenancy agreement, look through it, and then refer back to the residential tenancy office regulations, because it's not that easy. We've had a couple of instances over the holidays where people thought they could have the tenant moved out. You need to pay attention to it. Okay.
Yeah, very good point. Good. All right. So, Dick, we've never met officially. We've talked on the phone a lot. Nice to meet you. So, Dick works with Tony and the Spagnuolo group of many law firms, I think it's called now. So anyway, Dick has been very good about always returning phone calls, taking great care of us, and was generous enough to come to speak to you guys today about all things real estate and legal. So when I talked to Tony, we had talked a little bit about assignments as one of the things that's going on that people need some insights on, and also the problem with pricing and what you're just talking about now in terms of how we protect people in terms of getting the prices right. And that may or may not be something that's up your alley. But do people have other questions that they'd like to see touched on today, specific situations that you're dealing with? Ron?
If you have an assignment, for an example, a condominium sold for $1.5 million, and you're doing an assignment on it, and the lift on it is $300,000 to $1.8 million. is the GST payable on the original $1,000,005 or on the $1,000,008?
If you use the, I assume you're probably using, are you going to be using the real estate board form of assignment or the developer's form of assignment?
Well, the
Real estate.
Yeah, if you use the real estate board form of assignment, the GST is actually, there's a provision in that assignment form to deal with the GST, and it says that the vendor is responsible for the GST, so it's built into the actual purchase price. Now, whether there's in fact GST depends on the assignor. Certainly, there will be GST payable from the developer. The developer is always going to collect GST because for them it's commercial activity. But that original purchaser / assignor, whether he should be collecting and therefore the assignee remitting GST depends on what that assignor does. So if that assignor purchased the property to live there as a residential property, whatever circumstances he decided that he didn't want it anymore, he was going to be assigning the contract, typically there wouldn't be GST payable, so he wouldn't be collecting GST. But if this is a flipper, so he's bought 5 units, he's flipping them, there would be GST payable because that's in the course of commercial activity.
And the assignee would pay the GST.
Well, again, in that real estate board form of contract, it says that the purchase price is inclusive of the GST. But the question is always whether it's inclusive or not, whether the purchaser / assignor should be incorporating the GST into that purchase price when he calculates what he's selling the property for.
Is the assignee not consuming the contract from the assignor?
Yes, the assignee will pay GST to the developer, but only on the developer's original purchase price, not on the lift or the profit portion of it.
But if that property is registered in the sale of $1,000,008,
It won't register it. The sale of the property is 1.5. That's the contract on the property.
So this contract doesn't touch the other.
No, it does have a bearing on how we value properties too. You know, that one's going to close at $1,000,005 and someone paid $1,000,008 for it. Right, but when that thing closes,
That's right. So from the developer's point of view, he will only be collecting GST on 1.5.
The key there, Ron, was what Dick was saying is if this guy had 5 units and he was doing this with all 5 units, then he's probably exposed to GST.
That's right.
If
Yeah.
he was planning on living in it and his plans changed, then probably it's exempt.
So I think what you need to,
Well, probably though is
Well, we're
but
not that.
the assignment contract says it's included in it, and whether or not it's inclusive of GST if applicable. So the GST is always it's the situation of the seller that determines the GST. So the contract says it's included in this amount if it's applicable. So so whoever's selling it needs to know. If you're representing someone in the assignment, you need to have that conversation with them.
Yeah,
Your
sure.
buyer should be protected.
So if you do a contract on the assignment, should you take the contract to your lawyer and get a legal opinion on it?
you should, well, if you bring it to me, I'll tell you to take it to the accountant. Because the assignor or the original purchaser should be getting advice from his accountant. Should I be collecting GST on this? That's an accounting question.
And decision as to the intent of the original buyer. Who decides what the actual CRA is?
CRA. Well,
CRA is the end result, but how do you get a decision on CRA?
Well, you're right. I mean, in the end, what you're looking at is that original purchaser. What was his intention when he signed that contract? So if the intention, if that's his first purchase, he's never flipped a property before. I mean, CRA probably isn't going to contest the fact that, look, I bought this place and I was going to live there, but divorce, job move, I couldn't move in, and I'm flipping the property. But this is your second or third time doing it, they're probably going to take a little harder look on
But it's
it.
by no means black and white.
Nope, you're right. And that's the same with buyer buying a property and claiming the GST rebate. Quite often we'll have buyers purchasing a property. They intended to live there when they bought it, but for whatever reason, they didn't, they bought it, and as soon as the completion date comes, they sell it the next day. In those circumstances, they're entitled to the rebate because the intention was, when they bought it, they intended to reside there. Again, if it's your first time, GST office isn't going to take issue with that. Obviously, from a developer's point of view, they're a little more nervous because they've given you a credit for the rebate, and are they going to be getting an assignment of that from Revenue Canada for that later? So,
On that very same example, the 1.5, 1.8 property transfer tax, I might suggest or argue, and you can tell me if I'm right or wrong, that the PTT would be payable on the 1.8.
you're right. You're right, because that would in fact be the fair market value of the property. Yes, right.
Because the transfer tax is applicable, if it's a family property, you have to get an assessment to determine what the transfer tax is going to be at that time, even though that's not what you're paying. That's a great point, Dave.
Yeah.
You know, it happened to me with a detached house in Edgemont Village many, many years ago when the property transfer tax first came in. And there had been a period of time of like 120 days between the original contract and closing, and the market was doing something similar, and it had gone up, and the PTT somehow became aware of it.
Yeah. The flip of that is that when you get decorating allowances or sort of certain credits,
yes,
you can deduct those amounts for the calculation of the property transfer tax as well.
Good.
So on that example of 1.5, 1.8 flip, what's going to show up on the value on the land titles typically?
1.5.
The sale will show through at 1.5.
Sorry, say that again.
So on that example that Ron gave of the 1.5 with the 1.8 flip, when the title finally gets registered, what's going to show up on the land titles for value?
For the property transfer on the Form A transfer, you mean?
Yeah.
It will be whatever you've registered then the calculation of the property transfer tax act.
No, but he's talking about where it shows the sale going through, you know, the date and the history of the sale. It would register at 1.5 at land titles, wouldn't it?
Well, for the documents that we prepare as a law firm, the only place that would show up in a public record document would be on the Form A transfer. So on the Form A transfer, we typically put in a consideration for the transfer. So again, that on the example here, we would show that as 1.8.
Yeah, but if you put up the tax on our MLA system, it shows, as you say, history, right?
And maybe there would be some, you know, on ours, when we look at the history of sales on a property, it'll show rejected, not suitable for sales analysis if it was, and maybe I don't know if that.
Okay, I'm not sure where that data gets pulled from.
Yeah. Okay. Yeah.
So is there a paper trail that the conveyance completes to show the 1.5 and then the 1.8 transactions
For
that example?
For land title purposes, yes. On our end, as I say, on the Form A transfer that we prepare, we're required to put in a consideration amount.
Okay. So it isn't necessarily the price of the original contract.
Well, yeah, it depends on the circumstances.
Yeah.
I mean, so for instance, family transfers, we might put in $1, for instance,
right,
even though that wouldn't be the true fair market value of the property. So it depends on the circumstances of what's happening there. And of course, if it's different than what we're paying PTT on, there has to be some explanation.
So if a person buys a property, say for if they buy a property for $1 million with the intention of moving in, and they do move in, and then they decide soon after it's not right for them, they move out, they fix it up, they sell it for a higher price. Are they paying capital gains on that?
Well, yeah, that's more of an accounting question, but if my understanding, if it's a principal residence, probably not.
Just so I talked to Brian Doherty about this on Friday, and he said that the lift is income and it's all subject to GST. So I don't know. So there's.
Well, it would be subject to income taxes. However, whether it's subject to GST would depend on the activity of that.
If you're not a GST register, what are the greatest terms in the CRA? Is it adventure in the interest of trade or in the nature of trade?
Commercial.
In other words, if you're hoping to make a buck on this, you're going to pay GST on it. It attracts GST. Right?
Or if you're in the business of flipping properties.
Right. Yeah.
And right in the GST Act, it does talk about substantial renovations, and it defines what that means.
Right.
So if you think that just because you took basically the house down except for the foundation and you rebuilt a house, that's under the GST, the way that's written, the Act, you must pay GST back to $1.
Yeah.
It's not a renovation.
Yeah, it's very prudent to get to give that advice to your clients. It's tricky business now, right? It's tricky business, so they should be talking to their accountants. They should be talking to their lawyers about this stuff before they get themselves into a contract that they can't unwind. All of a sudden, GST is applicable. There goes 5% of a $2 million sale. Hello, you know, worth having that conversation. Good. It's amazing. You know what? I do find people are interested in GST, and that's shocking. Yes, Joe.
Can we move on to assignments?
Sure. Anything else on GST?
We often get scenarios, Dick, where because of perhaps a mortgage company wants somebody off the contract, or they want them added on, or we get close to closing, we get scenarios where somebody wants to sell it to their friend or their partner or whatever. Can you explain what would probably be the best way for us to approach this?
So I'm sure you all know that you can't just add or take people off contracts and title. Those are all either assignments or transfers of interests in land. So I know for laypersons, they think I'm just adding someone to the title. What's the big deal? But strictly speaking, those are assignments and transfers. If you're dealing with used property, so you're using the standard real estate board form contract, there's no prohibitions or conditions on assignments in a standard real estate board form contract. So they're freely assignable, in other words. So I know of practice among many realtors is to put in John Smith or assignee, but strictly speaking, you don't even need to do that. You can put in John Smith, and if the contract is assignable. If the contract if the contract has no prohibitions or conditions, you're free. The buyer is free to assign that contract to anybody else. There's no conditions on that. Now, of course, if you're dealing with a new development, it's quite standard for a developer to put in conditions on assignment. There's going to be conditions, sometimes straight prohibitions on assignments as well. But on a standard real estate board form contract, no, they're freely assignable unless the seller actually puts in there cannot be assigned.
Used to have table. What kind of a document would you use to add that name, or would you just wait for closing?
So, so the question then being, if it's freely assignable, anything, strictly speaking, no. There are a couple of things that sort of come into play there, though. So if there's a bank involved, there's a mortgage involved, a bank will always want to see the borrower's name on that contract, whether it's in an addendum or well, it's probably going to be an addendum. The addendum is either going to take someone's name off that contract or add someone's name to the contract. If there's a mortgage involved, the bank will have their own conditions and policies in terms of how they want that contract prepared, irrespective of whether the law actually requires it or not. So the law doesn't require anything, but of course the banks have their own conditions. So you'll be stepped with the policies of that bank. The other scenario is sometimes we'll run into if we're acting for the assignee, the end purchaser, the lawyer or the law firm acting for the original seller may say, well, why are we transferring to John Smith when the contract was in the name of Mary Smith or somebody else completely different? Again, strictly speaking, it's none of the seller's business. If I pay you $500,000, who does it matter the name of that transfer? What does it matter to you who it goes to? And at law, strictly, that's correct. But there are
people don't want to sell to specific parties.
Well, you're right. You're right.
In the contract.
Yep. But that should be in the contract then. There has to be some condition in there. But from a seller's lawyer's point of view, there is some risk there in that they may be concerned with if I transfer this property to John Smith, even though the contract is in Mary Smith's name, will Mary Smith have an action against me? What if she comes back to me and says, why did you transfer the property to John Smith? The contract's in my name. So now, practically speaking, that's unlikely to happen because documents are prepared. Mary Smith's lawyer should have prepared documents to send to the sellers and those things normally wouldn't happen. But there was a file once where there was a concern there. So I think even there, depending on who we're acting for, the seller might simply say, give notice to Mary Smith. I am transferring to John Smith, and just give notice that way to protect themselves. But strictly speaking, there's no requirement for any addendums or anything like that or consents.
But as a practicing realtor, just so I know, I was recently a seller's agent. A buyer purchased the property, the contract's binding. And about a month before closing, we were called and informed verbally that the contract was going to be assigned to another family member for whatever reason. And we really didn't care on that basis. And they said, well, that's fine. We just want your seller to acknowledge the assignment. And I said, we're not obligated to do anything. We're happy with the contract the way it is. So we just left it silent and it all went forward. I guess as a practicing agent, as long as I'm correct in saying that as a seller, we don't have to do anything.
Correct.
But in the case of that, if the bank is requiring that extra name to be added, the bank's going to want to see the seller's signature.
But that isn't anything.
No, but I'm just saying though, in a situation where you don't have to add, or you don't have to ask permission to add a new buyer if it's a family member, whatever, to the contract, a bank is a lot of times going to say you can't just add it without an addendum signed by both parties.
Yeah, that's right. That's right.
So you should still have something stipulated in that contract.
Catch 23.
Yeah.
Yeah, that's right. You're right. The so in that scenario there, the buyer doesn't need the consent of the seller to either add or take someone's name off or assign the contract. But if there's a condition from the lender requiring that, then again, strictly speaking, that addendum really only has to be signed as between the assignor and the assignee. Right. So you don't really need to bring the seller into that.
We can talk to the bank and most likely convince them that we can just do the assignment from the assignor to the assignee. The seller or the vendor doesn't need to sign that. And then give them our opinion. This is a valid assignment. It's a valid contract. So most times we can convince the bank that is enough.
To not involve the seller in that.
Exactly. So if the seller's taken that position, which they are certainly entitled to do, we can just speak to the bank. You know, we tried, the seller doesn't want to, but you don't need to worry about it. We have the assignment. Here it is. Anyway,
so why have a form in web forms, that clause that you would put in there about assigning? What's the
about why have it in there? It used to be and or nominee.
Yeah. Well, one of the things that clause says, and before I go too far, the guy talking down at the end there is Tony Spagnuolo. Hi, Tony. Alan Stewart. Nice to meet you. I know you were saving a death row inmate from being.
No, it's getting a coffee. Oh. I'm starting at 9:30. I thought I was early. I was meandering around, read the paper. Oh, no. I would have gotten social media, but I'm off it now.
Anyway, so thanks for being with us, Tony.
I've yet to work with a lender.
Yeah.
Will say, yeah, don't worry about it.
It'll take the lawyer.
You might have a great relationship with them from a legal standpoint, but if you're adding someone to a contract, they want an addendum. Yeah, just so.
They're super sticky.
Yeah.
And Brad, you had asked about that clause in web forms. So in what the professional standards manual says is in the absence of that form, then you have to notify the seller that you're changing the name on title at registration, which can open up a can of worms because it says you need to tell them that you're switching you're signing the contract. The clause that web forms has built says, or the BCRA has built says that you no further action. You don't need to tell them anything else because this is in the contract. So that's why people put it in so that they can blindside them at the end of the day.
And quite often, a lot of things in the contract are put in there really more for notice. So that, again, there's no legal requirement, but whether we're preparing a lease or any other type of agreement, sometimes we put things in there so that people know what the law is, that they're free to assign, et cetera, et cetera. So even though there's no legal requirement to do that.
Yeah. Sorry, what about FinTrack? I thought when FinTrack came in, we were told to make sure we add that clause in that says that the buyer reserves the right to add and give it a name that lists it.
Yeah, I don't know it's a good question, Rita. I'm not sure that the standard manual says if you know who it's going to be assigned to, or you know that you're going to be adding names on title, that should be in the contract. The buyer reserves the right to add the name of Dave Watt to the contract at closing. But if you don't know the name, then you can remain silent on it. But they do see.
It assumes the responsibility for FinTrack because we're supposed to be the police now for the government.
Yeah, it's always the agent that's involved in representing that side. And if there's no agent.
So now when this happens without our knowledge at the time with the lawyers.
Yeah, it's out of our hands. And the lawyers are smart enough not to do FinTrack, so they don't want to talk.
It's solicitor-client privilege. That's what it's called.
That's right. We have realtor-client privilege, apparently. Yeah. When you guys win that battle, can you let us know?
Yeah. So just to follow up, Dick, so the addendums that we do then, changing the name on the contract, what you're saying is they're not necessary?
No.
But it's a practice that we.
Excuse me. I sort of look at it more as a courtesy. to the seller, so that they're. But sometimes you may have a very uncooperative seller. He's not happy that you've been able to flip the property for $300,000 more. Why should I sign? Why should I be doing any more work on this? So but so it's just strictly not.
But when we're doing an assignment where there is a lift, it's probably prudent to have the assignment contract.
It certainly wouldn't hurt.
For sure. Yeah. And I think the what, like Colin said, the banks are the ones, they just check boxes. There's nothing in it for them to take any risk. So if you can get that addendum signed, it's going to solve a lot of problems, which is our job at closing, to make it as smooth as possible. So it's not always possible, but you hope they got deep pockets and don't need.
Or it just delays it.
Yeah.
So
Yeah.
if you have a tight subject removal and you know you're going to do that, get it done.
Let's avoid the pain.
Because it's a little bit frustrating because we have to go back to you as a manager and say, you need this, and then you're scrambling. So if you know that you're going to add someone, give them a heads up.
Yeah.
So does the bank want to see the vendor? Does the bank want to see the seller on that?
Yeah, they're gonna.
In a situation like that, then should we not have some sort of a clause, or can we even have a clause that states that the buyer reserves the right unilaterally to add somebody and it does not require the seller's signature?
Yeah.
Which is more than just saying can add at the time of completion.
Right.
Will a bank accept that?
No, that's the problem. Is the bank won't. It's contractually it's
Have the
fine,
seller's
but you got to get the
signature.
bank. Ideally, the bank's going to want to see the seller acknowledging it.
Unless it's done on an assignment form. On
Yeah,
an
the bank may
assignment
accept the
contract.
assignment.
And it depends on, sometimes clients have a certain relationship with their existing lender where you can get stuff done. But if you're looking to get your subjects removed and you need to move quickly, get it done yourselves rather than having your client have to bring your mortgage broker to beg to have an exception. Because it really will delay the process.
Well, keep in mind as well, it's the bank really doesn't care about whether it's assigned. They just want to see the name of the end mortgage or borrower on there, right? They don't really care whether it's assigned or not. That's
They
what they
just
want.
leave the rest to the lawyer.
Well, it's an interesting point. Sorry, interesting point with that, because they always say, the instructions come to us and we have to give them our opinion saying you're valid, because first charge on title. Then they still want 25 other things. Like if I give you my opinion, the rest should be irrelevant. But they still want the contracts witnessed, even though contracts don't need to be witnessed at law, but they still want that. But if we're giving the opinion, that shouldn't matter. I'm giving you my opinion, my professional opinion, your first charge on title. But they still have all the check boxes that they need to tick off. Sorry.
Yeah, going back to what Joe mentioned there regarding lifts and using an assignment form versus using an addendum. If there's, if the realtor's called upon to handle an assignment, you definitely want to use an assignment form. You don't want to be doing that on an addendum. Conversely, the assignee and the assigner could also go to their lawyer, and the lawyer could do the assignment form. But if there's lift, I think you definitely need to be using an assignment form rather than an addendum. Is that what you were speaking about, Joe?
Yeah, that makes sense.
Yeah.
On the
Yeah, Mark,
comment about bank wanting signatures witnessed, has there been any issues with DocuSign and Event-a-Sign because we're not witnessing them?
No. No, not that I haven't seen any. As long as there's, they're not looking to the validity of that signature. They don't want to see something or whatever it happens to be signed, whatever you want to call it. So that's fine. They don't look at the terms of the assignment agreement. They just want to see what's done.
No, but I mean in general with
No.
signatures.
No, that's fine.
But don't make the mistake of witnessing it for the bank if you have a witness.
Yeah.
No.
And when they call and say, just can you witness it? Yeah.
Never, ever.
Good. Dick, did you have anything you wanted to speak to specifically? We covered GST a bit. Or sorry, Dick, Tony, I know you've been thinking
Did you
about
cover
this more than
GST
Dick.
on the lift just because it was brought up?
We did. Yeah.
Okay.
Yeah, we did, which is
My work is done.
I just want to turn over to other questions. If you had specific stuff you want to talk about, we will save some time for you. I know you got some services you'd like to talk about as well.
No.
Any other questions for free legal advice?
About that, about the lift.
What, the GST in the lift? Oh, God. What did you say? This is where it gets awkward.
Just ditto what Dick said.
Yeah, I concur.
Yeah.
Coquitlam Court of Appeal.
Spoke about intent, so.
Well, GST is a little subjective. On the lift, and I'm pretty confident Dick said the same thing. It depends on the seller. If all they do is buy properties and flip them, it's their business and it's their commercial activity, and I think there'd be GST payable. If they're a school teacher and they bought their first condo They haven't closed yet, and then they decide to move to Fort St. John's. First time they've ever flipped, that is a flip, a condo. I think there's no GST payable. And in between, oh, nice. In between is the gray.
They're both.
And there's no, you know, you can't say this is when it's payable and this is when it's not. It depends on the commercial activity of the seller. So you're a realtor. If you sell 50 homes a year and you just flipped your first one in 10 years of business, there's probably no GST. If you sell a house a year and you flip 8 a year the last 8 years, there's probably GST. I use probably a lot. I'm 100% certain there might be payable.
Can we move on to those now?
Yeah.
Can you go over the importance of keeping the contract alive, have the dates of acceptance on there and renewing it? We see people wanting to breathe life into dead contracts.
Well, from a best practices point of view, you should obviously, if there's a date coming up, you need to extend them. If a date comes and goes, can you revive a contract?
Do you want to turn this off?
Is this being recorded? Oh.
My view is that, I mean, as long as both, and there's some, but it's one of those areas where it's sort of gray, and you don't need to go there, don't. But the fact that a date's been missed, you both sides want to complete. I think if you have or a change in the contract, it looks like they're still in negotiations and still looking at completing. I think that there's an ovation.
Would that be prudent then on subject removal if you had the seller sign the removal? Usually the subjects are unilateral.
Exactly, that's right.
So on subject removal, you had both parties.
Right, exactly. So that shows the intent there, that they're both, they don't see the contract as having terminated or being void.
Excuse, that contradicts legal advice we have received.
No.
So they say in best practices, and I think it's a good way to do it, is simply write a new contract and put it in front of both parties and have them sign it, and then there's no gray.
Yeah, absolutely. And that is the proper way of doing it. Correct. But we see it a lot where there's a contract, the day's come and gone, it's only a day. Both parties want that deal. It was an error of some sort, whether it's just a slip or clear or whatever. They thought it was the 16th, it was the 15th. A lot of people think they're buying the property on the possession date, not the completion date. So a lot of people get their dates mixed up, right? You can breathe life into that. It's not the best practices. Best practices, write a new one. But if both parties conduct themselves after the fact as to affirm that contract, so if they remove they both remove the subject removal. If the buyer still gets their inspection, removes it, the seller signs that off. If the seller still instructs her, then they've taken action after the fact. That would revive that contract. But it's not the best practice.
Now the market goes up.
Oh, if one party wants out, no, exactly.
Yeah.
No, and this is the risk you take. So if you take that, if you do that approach, you don't write the new one. Someone's got the right to walk. And if it's gone up 300 grand or 15% or whatever, that's the risk you take. And that's why best practices is write the new deal.
But stick with that.
Exactly.
Yeah. Let the lawyer sort it out otherwise. Yeah.
I think the more common one is you write an offer on a property and leave it open until 9 o'clock at night. And the seller says, we want to sleep on it. And then the next morning at 9, they say, okay, we'll take it. But it was only open till 9 the night before. These guys have said, you got to rewrite the whole contract because 9 o'clock go on. But you're saying not really, because they will still want
no, that's what I'm saying actually.
Because if there's this is being recorded, this is being recorded. We are not saying that
because there you do run a risk. There you do run a risk. So
the buyer walking away or the seller not taking it. The deal is dead.
I get that, but if at 9 o'clock the next morning they still both want to go ahead,
okay.
Says, yeah, I'm happy with it, I'll take it, and signs off on the original contract that expired at 9 o'clock the night before.
Yes.
And like say even changes the date. Like these guys are saying you can't do that.
Well, okay. So in that scenario, if both sides had simply forgotten at 9 o'clock to do something, and the next morning they both said, "Oh, sorry, we forgot. Let's just do an addendum, and we're going to extend the date." If both parties sign that, to me, that's all right. You don't need to do a whole new contract. However, I'm not saying that at 9 o'clock we should just, wait till the next morning. That's very.
But they would, I mean, that would be a counter offer, right? When your sellers slept on it now, they get up at 9 the next morning, they go, you know what? I'll take that deal. They would strike out the date open for acceptance date and put in a new date that allows the buyer time to sign to gel it together, right? So
Correct, I get that.
Yeah.
I get that.
Yeah, but at 9 o'clock, if you catch it and somebody's saying I want to sleep on it, for sure you want to extend it.
Yeah. As for the
that I'm talking about a scenario where both sides have, for some reason, simply missed it. And then they decide to go ahead and complete on the original contract. I don't think you need to do a whole new contract.
I think we have to be careful about what might work in the legal world and what might be looked at in terms of the real estate council discipline committee or the real estate board. So if it's 9 o'clock and it's 9:01, that offer's dead.
Yeah.
You
That's
better
how
do
we treat it.
something else the next morning. Otherwise, if someone then decides later on that they go to their lawyer and want to back out, you're going to be in front of discipline.
Yeah, and again, I'm not saying that you don't need to do that. You should be doing that. My understanding was that the hypothetical that you had given me was that it was missed. The next morning, both sides agreed that they would continue on.
The common problem in this business right now is people it doesn't seem to matter in some people's minds that 9 o'clock is significant. And, hey, well, we'll just verbally extend it.
Yeah.
No, but I'm saying you still change the time at 9 o'clock the next day to say open till 10
Why not
o'clock in the
change it
morning
9
and you
the
both
previous
agree.
You have to change it the night before.
Just get an
Oh,
initial.
okay, that.
You have to change it
Prior to
before 9
p.m.,
o'clock.
extend it till 10 a.m. the next morning.
Otherwise, it's dead.
Yeah, you don't want to take the risk. You don't want to take the risk. You should.
Accept it at 8:30 p.m.
Get stronger.
Andrew's got a question. He's been waiting patiently in the corner.
The fact is that if I'm representing a seller and they have a contract and then the time expires, we go to the next morning, and then everybody agrees and they make an amendment and that all the signatures are there, but it's late and that deal was technically dead until they revived it. Somebody calls me and said, my buyer wants to offer $300,000 more for that house. Is your seller able to sell it? I have to show that contract to my seller, and they call their lawyer and they say, can I get out of this?
Sorry, is this before or after they signed the addendum to extend?
After they sign the addendum.
Well, if they've signed the addendum,
Can the seller get out of it if it's in their benefit?
my view is no.
No, their actions have ratified that first deal. It may have been,
Okay.
I mean, it's not the best practice. The best practice is to either get it accepted or extend the time. But third thing down the list, okay, change it the next morning to 10 a.m. and sign it before. It's done at that point.
As long as everybody's agreed to it.
That's not best practice.
No. Someone told me once there's only one opinion that matters in this case, and that's the opinion of the judge. And you don't want to have to go and find out what that is. You know what I mean? So we're trying to do on the way through here is mitigate ever having to stand in front of him and talk to him.
So for clarity, that offer expired at 9 o'clock at night. Nothing happened that night. At 10 o'clock in the morning, the buyer comes back and the buyer says, yes, I've decided to accept that counter offer. The buyer changes the dates till noon, the acceptance date and his offer open date. The seller signs off on those dates, initials those dates. Everybody's initialed off. It's 10 or noon the next day. That's a solid deal.
Yeah.
I
that was
think
my
what council
question.
would want to see is a brand new offer. Change all the dates.
Well, there's actually a bit of a misconception. The council talks about subject removal dates. If a subject is not removed on time, the real estate council says that contract is dead, absolutely dead. This is what the real estate council says. So there's two different issues. There's the issue about the subject removal date, and then there's an issue when you're negotiating a contract. Two separate things.
Yeah.
Sorry, can I add something?
Yeah.
Just because I get it a lot, and it might just be where I'm doing business and different ethnicities and stuff like that. But your offer's open till 9 o'clock to accept or counter. You don't need a seller or buyer does not need to respond if they don't want to respond.
No.
At 9 o'clock.
No.
Correct. Okay, so I get it all the time.
But that offer's dead now.
It's
There's no more offer.
It's dead, absolutely.
Yeah, but then the seller could write a counter offer the next day.
Right.
Yeah.
Yeah, just so people are clear, because it's always, well, you need to send it back to me by 9. No, they're not accepting it.
Right.
If they decide to counter you, they'll counter you.
Yeah.
Another time.
Yeah.
Okay.
Yeah. Accept, reject, or ignore.
However you
Yeah.
have to do it.
Yeah. Good. Any other questions? I wonder, Tony and Dick. Sorry, Tommy. Go ahead.
So, given the flipping activity of late, and given our responsibility if we're representing a seller to price the property properly, as a protection both to ourselves and to our sellers, I'm going to start using a clause for potential assignments that property is assignable, but there's going to be a fee payable back to the seller of 50%, 30% of a potential lift if the property is assigned prior to the original completion.
It's a great
Just
point.
like the
Yeah,
developers.
just like the developers.
developers,
So the risk in that is you will lose the appetite. You may. Like we have a number of realtors in our offices that just respond and says this contract is not assignable without prior approval of the seller, period, right? You want to sign this thing and make some money, you tell me what you're going to make and we'll have a conversation. So it's not assignable. And what we've seen is certain buyers and agents that represent buyers looking to make investment flip kind of purchases just ignore their listings. So I think it's really important to have the conversation client and say, listen, this is what's happening in the market. I'm telling you what this thing is worth today. If we got a 3-month close on this thing, I have no idea what it's going to be worth in 3 months. And it may go up considerably. If you want to have a say in that conversation, then we need to protect you here with this clause. But you must have to appreciate that there is some risk that you're not going to get those kind of offers anymore from the original investor guy who's willing to pay you fair market today because he's looking to increase on that. So I think having the conversation is great and having some kind of a boilerplate saying, and then they just fill in the blanks. How much of the lift you want? Well, it depends how much they're going to make. If they're going to make $1 million, I want a lot. If they're going to make 100,000, maybe I'm not as concerned. So I think it's a good conversation to be having with your sellers before the thing actually hits the market. Yeah. Do you guys have any comments on that?
No, that makes sense. I mean, developers do that all the time.
Yeah. Yeah. I think it makes perfect sense, especially with the inventory levels they are now. Yes, Judy.
I have a concern more than a question. And the concern is when you have a listing and you receive all these calls from potential buyer agents, and they're saying, well, what's your client's bottom line? What are they going to go with? Like, is that just course of conversation now? It blows me away. 90% of, if you're acting on behalf of your seller, you're not disclosing that.
Yeah. Let's hope not.
Honestly,
Yeah.
I was shocked
Yeah.
at how many calls ask
Say they'll accept full price.
Yeah.
Exactly.
So they might. Depends. Yeah. It depends. Yeah. Just ask, well, what's your buyer prepared to pay? What's your buyer's top dollar? That's what we really need to get to here. What's your buyer's top dollar?
That's a good one. Yeah, that'll be a good one.
Yeah, that's right. Yeah. What drives you guys nuts about realtors?
Oh, no way. This is being recorded.
Absolutely not.
Nothing. Love them all. Love them all.
But there must be.
Absolutely nothing.
There's got to be, we do contract review all the time. Chris doing more now lately, thank goodness for me. But there is stuff you see that just is like, oh, here we go again. Have you got some of those things that here we go again that would be good to talk to these guys about?
That's probably better for you because you do more of the day-to-day stuff. What do you think?
What about legibility, Dick, of the contract?
Have you seen his writing?
Yeah. Sometimes we get stuff that's turned in that you can't read.
Yeah. Yeah.
How do you guys?
I actually I have to say the conveyancers in our office deal with that more than I do. But I certainly do see the faxes of the faxes coming in. And but I think most realtors tend to have, I mean, they do this the courtesy anyway, sending in one for clarity purposes. So that one's not such a big deal for me. Again, the conveyancers might have something
residency of the seller. We see a lot of
good one.
contracts
That's a good
where
one.
Residency is
I think for us, I think it's important to identify whether your seller is a resident or non-resident. I know, in speaking with some realtors, I know apparently your insurers perhaps are telling you not to give that advice, and that quite often means that contract is coming into us with both boxes left blank. But even if you're not prepared to go through that with your client, I think you need to have your client go to a lawyer or an accountant to say, you know, are you a resident or non-resident? You certainly don't want to leave that to the last minute, because if that box is left blank, and you're acting for the seller, a buyer has no idea, and their lawyer is going to advise their client to take the safe route and hold back 25% because they don't know whether they're dealing with a non-resident or not.
Of the sale price, not the equity.
And keep in mind that the Income Tax Act is pretty strict. If a buyer thinks they are dealing with a non-resident, as a right, they can hold back 25% of the purchase price. And a seller cannot sue a buyer for doing that if they're acting in good faith.
Wow. So did you hear that? That's a right to hold it back.
Yeah.
Until they get a CRA.
Exactly, that's right.
But that's months.
So
That's after
you're
closing.
dealing with
Correct.
a seller and a seller's agent that you don't trust based on what you see of where the seller is, where the seller's signing from, etc., their status. How do you get clarification, or who do you get clarification from? Do you need to know from the seller's lawyer or
Yeah,
accountant?
the seller signs a stat deck.
Yeah. So it will depend on the circumstances. So if I mean, 99% of the time it'll just be not resident of Canada. And, you know, the title search will show a local address. You don't need to get into any of that. Sometimes you'll deal with a seller that's signing documents overseas. The title search shows a foreign address. You know, if there you're going to want to start making some inquiries. However, you have to be a little careful, because the more you dig, the more stuff you might find, and the more that you can no longer rely on representations from the seller.
So a conversation to have, you're representing the buyer in that situation. Is that what we're talking about?
Well, if you're representing the buyer and the seller's agent are resident of Canada,
Yeah,
but, I mean,
but you
they're
don't think
signing
so?
from Taiwan, or they're signing from somewhere else, and it looks as though the house has been rented for years, how much do you trust that?
And I think you could at least give them the advice to Dick that they do have the right to hold back 25% of the sale proceeds until you're satisfied.
Unless you get
because the CRA is coming
they
for
are
you.
an actual
Yeah.
resident.
Yeah.
But I think in that situation, what you want to do is pass the risk.
Yeah.
So you phone up the buyer's lawyer and say, look, here's our concerns. They ticked off the box, but we've dealt with them. They talk seats, it's been rented for years. Now you're passing the risk to, hopefully not us, but some other law firm. Give us the easy ones. No, I'm just joking. But you know what I mean? So you've done all you can do. You've identified there's a risk. That's the extent of your obligation on that file. Now it's up to the lawyer or the notary acting for the buyer to investigate. And if they're not happy with the standard stat deck, maybe they beef it up, or maybe they do whatever it is, but it's no longer your obligation, and you've alerted your buyer to the issue.
And maybe even having the conversation with them saying that you need that tick box ticked off. Otherwise, we're going to have to look to maybe hold back 25% of the sale
And
price.
Fabulous Seek Independent.
My guess is they'll tick that off. Yeah.
And I think 25% is a minimum. I've heard of lawyers
Is that right?
to hold back 35%.
Depending on the use of that.
Danielle, I'll come back to yours for a second. What I want to do is give Tony and Dick a chance to talk about what's going on in their business, and then we'll have a few minutes left over to go back and answer some other questions. But I don't want to run you out of time. So if you want to talk about a new service that you guys are going to be unveiling this year.
Yeah. No. I can see over there. They can see me, unfortunately. Gray and bald. That's a bad combination. So a lot of times over the years, we've been chatting with realtors in situations like this, and one of the comments that comes up are these non-financial charges on title, these easements, covenants, rights of ways, and it's one of your obligations to pull those for your client, for the buyer. And it's not generally a big deal in single-family homes. There might be one or two of them, sometimes a few more. But on strata, there's a significant number on a lot of these strata units. We pulled one, there's 25 charges on it. So that's not uncommon on a phased development type situation. And so most realtors will pull them on the single family homes, especially, you know, where there's a bigger commission up here, and expensive homes, obviously. But on stratas, I'll say a lot of realtors don't. What's the risk? What can go wrong? That kind of stuff. And there's usually 2 or 3 reasons why they're not being pulled. It costs you money. It costs you time. You have to review these things. You have to pay for them at the land title office, and they're about $15 a pop. But if you need one of the older ones, you have to send an agent to go get it. It could be a couple $100 for one of these charges. And then you have to explain it to your client, hope that they understand what you're saying. So there's risk, time, and money on your part. So over the years, we've been reviewing these charges, and we have a pretty decent sized library of these non-financial charges. And starting September of last year, we started ordering them on every single file that we do, whether we need it or not. So now we have thousands of these things, and what we're doing is we're preparing legal opinions on all these charges. So what we're starting as soon as our website guy and our PayPal account gets activated, but hopefully by the end of the month, is a service for realtors whereby for a monthly fee of $85 plus GST, you get your title on the listing. You can send that title to us, and we will pull every single charge that's on that title, every single non-financial charge. We don't pull the mortgages, we don't pull judgments, because that's the obligation of the seller, and that's going to be cleared on title. But every easement, covenant, right-of-way, undersurface rights, whatever it is, we will pull those and we will send those to you, along with a one-page legal opinion as to what it says. Very simple to read, very easy. So you can simply take that email from us and either print it on your letterhead and give it to the client, a nice little package, or you can just forward that email to your client. So you no longer need to pay the land title office or your office here for those charges. You no longer need to review those. You can just read our opinion, which is really about a paragraph, because part of it's a sales pitch and part something else. And you don't already take the time to read all those things. So for $85 a month, I think it has some advantages. We've been doing this for about 15, 20 realtors already in the Tri-Cities, just as a test to see how it went in the fall. And what we found is there are some extra benefits as well. When they were going in for listing presentations, they would pull the title beforehand. So they would pay the $10 for the title search. They would send that to us before they went in for the listing. We would review those charges before the listing presentation and send it back to the realtor before the listing presentation. So they went into the listing. If Dick and I are going in, we're two different realtors. We're both going in for the listing presentation. We had the exact same arguments, discussions, same, all things equal. If I've taken the time to pull the title, review the charges, engage a law firm, have them removed or reviewed, sorry, it might give me a better chance of getting that listing. And a few realtors have found that already. Other realtors pull that after they get the listing. And then when an offer comes in, they get a phone call saying, we're going to make an offer tonight. Okay, well, listen, I'm going to send you the charges right now. Not accepting offers subject to title review. Here's all the charges. Review them right now. And the other thing is that those realtors are finding that it's just kind of helping them appear to be a bit more professional. Take that for what it's worth. But they just seem to find that if they've taken the time to do it, especially when they get the listing or even before, it just gives them that much better a presentation to their client. So there's 5 or 6 advantages that, and I can give you the names of the people who are using it if you want to talk to them and see if they like it or not. But we're starting this, we're starting it now. And if you want to take advantage of this, just either give me your card or send me a note. You can start doing it right now. We're probably not going to start billing until February 1st. It'll just be a monthly bill on your credit card, like Netflix. You're just going to sign up on our website. Please don't share. Please don't be like my mother-in-law who won't spend the $8 and has to go on my net. But that's a different story.
Netflix is only $7.99.
But these charges are $15 minimum. So if you're ordering 5 charges a month, and if you're getting one of the older ones, you're saving money. Yeah. So I think it's I hope it's a savings for most of you, plus all the other advantages. Obviously, a lot of you will not take advantage of it. Some of you will. The 15 or 20 realtors, they've all signed up. So
have you thought of a corporate rate?
I don't think the offices would pay the office.
No, we could get the salespeople to pay for it, but if we did it corporately, I mean, that's an option.
In terms of billing, that kind of stuff?
Yeah, we bill the salespeople if they wanted to be a part of it, but we'd have a minimum of, or you'd have to have a minimum of.
See what my life is
Well,
like?
it would be X dollars a month. It wouldn't be, no, it wouldn't be if 50 realtors from the office signed up, you get a discount. I mean, it's only $85 a month.
I guess that was my question.
But, no. But if the office were to sign up and say, okay, it's, I don't know, 10, 5 grand, 7 grand, 8 grand a month for everyone in the office, and then you split that up with realtors. We can chat about that. I'm trying to keep my life simple though right now. It's $85 a month per realtor. That's it.
That's great.
Now we'll see how it goes. I've had some people say, can we just order it per charge? I think I would price that so high, you're better off paying the $85 a month.
We got, Mark, is that about the service?
Yeah, just to clarify, so you're talking about every charge, even on the common property?
Everyone.
So when you review that, you take an actual look at that particular charge and on that particular property and give an opinion on that.
Yep.
What the effect of that
specific.
Great charge.
Absolutely. We pulled that charge from the title or the common property. we review that charge with that registration number, and we send it to you with that registration number.
And do you convert meets and bounds to feet?
Yeah, I haven't seen many of those.
You
No, it's been a
have
while.
this all filed away. What about recent charges? Do you pull up?
We pull every one you send over.
Time?
Yeah.
If a property is being subdivided right now, if you have a client taking one lot into two and the city wants 3 covenants and 2 easements, the moment they're at the LTO, the moment you send us the title, we pull it. There's going to be, I mean, we have a couple of thousand charges. I talked to the deputy registrar at the LTO. They think there's 300,000-400,000 charges at the land title office. So, you know, we have this out of this. So we're ordering charges all day long. It's not like we have them all already. So, and so the turnaround, no, I plan on running this province-wide.
Yeah.
There's no restriction to use us for the conveyance. So if they want to use their law firm or their notary, God bless them. There's no term to this. You try it for 3 months, don't like it, no problem. Let me know, unsubscribe, give it a shot.
Guaranteed $85 forever?
Nope. Absolutely not. But yeah, certainly for the first year, we'll see. But in the there's one other thing. I should know that. Turnaround. That was a thing. So we're trying for, so far we've been able to fit it all within a 3 business day turnaround. That's only 15, 20 realtors so far. Now, if this takes off in the next 3 weeks and I get 200 realtors sending me 5 charges a day, I got some issues. So what we're trying to talk to realtors about is, look, if it's your listing and there's no offer coming in, let us know. We know we can put that kind of to the back. If you've got an offer that the subject removal is tomorrow, let us know that. And we'll put that to the front. Now, if you're every one you send us has to be done by tomorrow, we're gonna have a little chat and our fees might go up. But as long as it's, you know, an equal mix, what would I hope to do is to make this kind of the standard. So every realtor does this when they take the listing. And it's just done. And if we can make this kind of the standard practice out there, I think it just makes for a lot easier later on at subject removal.
For sure. We do. We've got houses on tour, so I'm going to.
Okay.
Is it specific to this service?
Yep. Are you comfortable with me attaching your opinion and the covenants or whatever to my listing? In other words, I try and make documents public, and we have that ability technologically.
What's that new thing called now? Not Pandora. It's some.
No, this is just on a normal listing. We'll post the disclosure statement. Easements that are important or whatever.
But I don't know about that. It's a good point, and I just haven't come up with an answer. Right now, I don't, because if you're doing a strata unit in the 200 unit building, those charges are overall 200. So I lose the ability to get the next realtor who's got, because those things are on there and someone else can just pull them. So right now I'm asking realtors not to do it. If I could find a way to make it, if you could take that off after your listing was gone, then fine. But I don't know if you can do that on that system.
You can do it.
Yes, you can do it. And
I don't know how I'm going to check that.
That would be help, but it avoids having to have subjects on contracts when you've got a multiple listing offer situation, listing broker, you provide this information. So everybody comes to the table armed with the same info.
Yeah.
So if you had to ask us to remove it, we could probably arrange something.
I don't have access.
Shared, but not as an attachment. If it's okay with Tony.
Yeah, we're asking you in our emails just not to share it with people unless they're party to the transaction.
Yeah.
So if another realtor says, "Hey, listen, you've signed up for Spag's account here.
Yeah.
Let me give you $20 and you order these things," and I find out about that.
I understand.
You're dead to me. Turn off the love. Phone up my cousins from East Van. We'll chat.
All right. That sounds like a great service. Anything else you should know about Spagnuolo Law?
If you're interested in that stuff, just send me a quick note, Tony at Spag's Law. Then I'll know to follow up when we get up and running.
Yeah. That's a great service.
And I'll be really quick.
Sure,
I know
Colin.
that everybody's completing and turning things around really fast. What are you doing as a minimum? Because I know, are you saying we cannot get to this file?
Well, that all depends. So the turnaround time now, and usually I start talking about this stuff in May. If you have a deal in June, you better phone the lawyer before subject removal, because June's just out of control and everyone's swamped. January, we can get a deal done. My staff aren't going to see this, right?
No.
The staff can get it. We can probably get it. If everything lines up perfectly, we can do a deal in a day or two. We cannot do that on almost any other time but January, because January is the slowest month of the year for our closing. So we generally would like 2 weeks notice of the deal. And notice is simply a phone call, an email, an online submission. And then we'd like to have a week with all the info. mortgage instructions, which never comes, a week before. Well, during the 4, 5, 6 months, right? The contracts are usually pretty good, and the client information. Clients can start their file on our website, so they're sitting around at night. They can go and do it. They don't need to play phone tag and go back and forth.
So 2 weeks notice in a week is
in a perfect
that's
world. Yeah,
good thing to talk
a
about.
bit more in June, July, August. Those are the 3 busiest months of the year, and everyone's flat out. And every June, July, August, we, along with a number of other lawyers and notaries, certainly the busier ones and the better ones, will turn away files.
Yeah. I promised Daniela. Last question.
Question,
Yeah.
is an estate always a resident of Canada?
Not necessarily.
No.
Depends. It
What
will.
determines, like the executrix or executor or?
It's the estate. So the deceased.
So
What's
was the deceased already? Okay.
Yeah. Okay. That's perfect. Can I get a round of applause for these guys? Who've been very helpful. Thank you very much for coming. Very good. Thanks, Tony. Thank you. Appreciate it. That's all I got for you. So we've got a sales meeting next Monday, same time, same place. And don't forget the kickoff on January 25th, probably 10 o'clock start. We'll send out some more information to you. Thanks, guys. Thanks, everyone.